Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute legal advice, professional counsel, or the formation of an attorney-client relationship. Divorce law is a highly complex field that varies significantly across different state jurisdictions and is subject to frequent legislative changes and judicial reinterpretations. The historical analysis, case studies, and legal trends presented in this masterclass are intended to provide context and perspective on the American legal system, not a blueprint for specific legal action in your personal life. You should conduct your own due diligence and consult with a licensed, qualified attorney in your specific jurisdiction before making any decisions regarding your personal, financial, or legal affairs. For over a century, the American legal system operated on a singular, high-stakes premise. If you wanted to leave a marriage, you had to prove your spouse was a monster. You needed evidence of adultery, extreme cruelty, or abandonment. But in 1969, a pen stroke in California changed the trajectory of millions of lives, effectively ending the era of fault-based litigation and birthing the modern no-fault divorce system. Today, approximately 70 to 80% of divorces in the United States are initiated by women, and for the American man entering this system, it often feels less like a court of law and more like a historical meat grinder designed for a social era that no longer exists. If you feel like the system is tilted against you, you are not imagining it. You are feeling the weight of 200 years of legal evolution that hasn't quite decided if it wants to protect the traditional family unit or the individual's right to exit it. This masterclass is designed to pull back the curtain on that history. By the time we finish this 10-part series, you will understand the historical mechanisms behind alimony, the origin of the tender years doctrine in custody battles, and why the shadow of the law determines your bargaining power long before you ever step into a courtroom. We are solving the problem of the uninformed defendant. You will learn how to look at your case not as a personal tragedy, but as a data point in a long-running legal experiment, allowing you to navigate the process with a level of historical clarity that most men simply do not have. To understand where a man stands in a modern U.S. divorce court, we have to travel back to the era of English common law and the concept of coverture. In the 18th and early 19th centuries, the legal identity of a woman was effectively submerged into that of her husband. While modern interpretations often view this solely as a patriarchal tool of oppression, from a legal history perspective, it was a complex web of mutual, albeit unequal, obligations. Under coverture, a man was legally responsible for his wife's debts and even certain crimes she might commit. This historical root is where our modern concept of maintenance or alimony begins. Because a woman could not own property or earn a living independently in 1820, the law required the man to provide for her for life, even if the marriage dissolved, provided he was the at-fault party. When we look at historical trends from the mid-19th century, specifically the rise of the divorce mills in states like Indiana, we see the first cracks in this system. Men and women would travel to Indiana because the state had significantly more relaxed fault requirements. This created a jurisdictional competition that still exists today in the form of forum shopping. If you are a man in a high-asset marriage today, the historical precedent of forum shopping is why your spouse might file in a specific county or state known for favorable equitable distribution laws. The legal history of the U.S. is a history of people moving across state lines to find the judge who would give them the best deal. The most seismic shift for men in American legal history occurred between 1969 and 1985. Before this window, divorce was a fault game. If a man was a provider and faithful, it was very difficult for a wife to obtain a divorce and take half the assets. The innocent party was rewarded. However, the 1969 California Family Law Act, signed by Ronald Reagan, who later called it one of his greatest legislative regrets, introduced no-fault divorce. This shifted the power dynamic overnight. Case studies from this era show that the move to no-fault divorce led to a sharp increase in unilateral filings. The legal bargaining in the shadow of the law changed. In a fault-based system, the person who did not want the divorce held the leverage. In a no-fault system, the person who wants the divorce the most holds the leverage. For many men in the late 20th century, this meant that their historical role as the provider no longer offered the legal protection of a permanent contract. We must also examine the tender years doctrine, which has a fascinating and often misunderstood history. In the early 19th century, fathers almost always received custody of children because children were seen as a source of labor, and the father was the legal owner of the family's assets. However, as the Industrial Revolution moved fathers out of the home and into factories, the legal pendulum swung violently in the opposite direction. By the early 20th century, the tender years doctrine became the standard, asserting that mothers were naturally better suited to care for young children. This historical pivot created the visitation model that many fathers struggle with today. Although most states have moved to a best interests of the child standard on paper, the historical ghost of the tender years doctrine still haunts many family courtrooms, influencing potential outcomes in ways that often favor the primary caregiver model over the dual provider model. As we dive deeper into the data, we see the financial implications of these historical shifts. In the 1970s and 80s, the feminization of poverty became a major political talking point, leading to more aggressive child support enforcement and the federalization of child support via the Child Support Enforcement Act of 1975. For the modern man, this means that child support is no longer just a private matter between parents. It is a state-monitored obligation with federal oversight. The historical trend shows a move toward standardization. Instead of a judge looking at your specific lifestyle and needs, they now often use a rigid formula, a historical reaction to the perceived inconsistency of judges in the mid-20th century. Another critical area of study is the evolution of equitable distribution versus community property. If you are in a community property state like California or Texas, the law views the marriage as a literal 50-50 partnership of assets from day one. This is rooted in Spanish and French civil law influences. Conversely, states following English common law roots use equitable distribution, where the court decides what is fair, which doesn't always mean equal. Understanding which historical legal branch your state grew from is the first step in predicting how your house, your 401k, and your business might be divided. Let's look at the case study of Or versus Or 1979. This was a landmark Supreme Court case where the court ruled that alimony laws that only required husbands to pay wives, but not vice versa, were unconstitutional under the Equal Protection Clause of the 14th Amendment. This was a massive win for the concept of legal gender neutrality, yet historical data shows that men still represent the vast majority of alimony payers. The law changed on the books, but the historical inertia of the breadwinner model continues to influence how judges exercise their discretion. In this deep dive, we are also going to analyze the shadow of the law theory, popularized by legal scholars Nookin and Kornhauser in 1979. Their research suggested that the vast majority of divorces are settled outside of court, but those settlements are dictated by what the parties think would happen if they went before a judge. This means your negotiation strategy today is being governed by legal precedents set in the 1980s and 90s. If you don't know the history of how your local courts handle wasteful dissipation of assets or imputed income, you are negotiating in the dark. For example, if a man has historically earned significantly more than his spouse, the court may impute his income, meaning if he loses his job or takes a lower-paying role, the court may still require him to pay support based on his potential earnings rather than his actual earnings. This legal concept traces back to the historical desire of the state to ensure that the public does not have to support a divorced woman and her children. The state, historically, would rather the ex-husband pay than the taxpayer. This state interest is a silent third party in every divorce proceeding in America. We are going to break down the step-by-step evolution of how marital property is defined. In the past, if you brought a business into a marriage, it was yours. Today, the commingling of assets and the concept of active appreciation mean that if your spouse so much as answered the phones at your business once a year, they may have a historical claim to the increase in that business's value over the duration of the marriage. This is a far cry from the 19th century view of separate estates, and it represents a move toward a communal view of marriage that many men are unprepared for. Throughout this series, we will examine data from the American Academy of Matrimonial Lawyers to see how the introduction of domestic violence injunctions and silver bullet tactics in the 1990s changed the landscape of custody battles. We will look at how the 1992 case of Planned Parenthood versus Casey, while a healthcare case, reinforced the legal concept of individual autonomy that further eroded the covenant view of marriage in favor of a contractual view. This distinction is vital. If marriage is a covenant, the state protects it. If it is a contract, the state merely manages its dissolution. By understanding that you are operating within a dissolution management system rather than a family protection system, you can adjust your expectations and your strategy. This is not about cynicism. It is about historical literacy. We are moving from the era of what is fair to the era of what is the statutory formula. And the men who win, or at least don't lose everything, are the ones who understand the machinery of the American legal tradition. To navigate the current landscape of 2026, we have to address the most pervasive myth in American divorce, the clean 50-50 split. While many men enter the process assuming that a simple division of assets is the standard, historical legal trends suggest that the concept of equality in a courtroom is often subordinate to the concept of equity. To understand this, we must first look at the death of title theory. For most of American history, if your name was on the deed, you owned the property. If your name was on the bank account, the money was yours. However, the mid-20th century saw a radical shift toward the marital property theory. This historical pivot redefined marriage not as a union of two separate estates, but as an economic partnership. This means that in 2026, the question is no longer who paid for the asset, but when the asset was acquired. Imagine a man named John in 2026. John is a software architect who founded a small tech consultancy in 2019, 1 year before he married his spouse. At the time of the wedding, the business was valued at $500,000. By 2026, through John's hard work in the booming AI sector, the business is worth $5 million. John assumes that because he started the business before the marriage, it is his separate property. Historically, he would be correct. But modern case studies in equitable distribution jurisdictions tell a different story. The court will look at active appreciation. Because John worked on the business during the marriage, the $4.5 million increase in value is often treated as a marital asset. The historical logic here is that by John working on his business, he was not working on other marital endeavors, or his spouse was providing the domestic stability that allowed him to focus on that growth. This is the first trap for the modern man, the blurring of the line between what you brought into the marriage and what the marriage created. To understand how we got here, we have to look at the two distinct legal trees in the United States: community property and equitable distribution. Community property states like California, Arizona, and Texas trace their lineage back to Spanish and French civil law. These states operate on the historical trend of a hard 50-50 split of all assets acquired during the marriage, regardless of who earned the money. This is a mechanical, almost mathematical approach. On the other side, we have the majority of the U.S., which follows the English common law tradition of equitable distribution. In these states, the judge has the historical mandate to divide assets in a way that is fair, which is a subjective term. Potential outcomes in an equitable distribution state can be wildly unpredictable. A judge might look at the future earning capacity of both parties and decide that a 60-40 split in favor of the lower earning spouse is what is fair to ensure both parties maintain a standard of living similar to what they had during the marriage. This leads us to a landmark historical case study from 1985. O'Brien v. O'Brien. In this New York case, the court made a revolutionary and controversial decision regarding a medical license. Dr. Michael O'Brien had attained his medical license during his marriage, with his wife providing financial support during his studies. When they divorced, the court ruled that the medical license itself was marital property. This established the historical precedent for enhanced earning capacity. Even though a license is not a physical house or a bank account, it was valued as an asset based on the projected future income it would generate. For the man in 2026, this means that professional degrees, specialized certifications, and even celebrity status or a massive social media following can be valued by expert witnesses and divided as if they were cold, hard cash. Now, imagine a second scenario involving a man named David in 2026. David owned a home before marriage. To be safe, he never added his wife to the deed. However, during their 5-year marriage, they used David's salary, which is considered a marital asset, to pay the mortgage and renovate the kitchen. David has just committed transmutation by commingling. By using marital funds to pay down the debt on a separate asset, David has historically invited the court to view that house as partially or fully marital. In many jurisdictions, the house is now a hybrid asset. The court will use complex formulas like the Moore-Marsden rule to calculate exactly how much of that home's equity belongs to the marital estate. This is a step-by-step process where the court determines the home's value at the date of marriage, the amount of mortgage paydown during the marriage, and the percentage of appreciation attributed to those marital payments. The historical evolution of alimony or spousal support is equally critical for the modern man to understand. Historically, alimony was a life sentence. It was designed to prevent a divorced woman from becoming a ward of the state. However, as the American workforce changed, so did the law. We moved into the era of rehabilitative alimony. The goal shifted from lifelong support to a bridge to help the lower-earning spouse become self-sufficient. But here is the historical catch. the duration and amount are still heavily influenced by the standard of living established during the marriage. In 2026, if a man has provided a high luxury lifestyle, the court may maintain that lifestyle for the spouse for a significant duration, regardless of her ability to work. We see a historical trend of permanent alimony being abolished in states like Florida, replaced by formulas that cap the duration based on the length of the marriage. This is the statutory formula era I mentioned earlier. We also have to discuss the double dip phenomenon. This occurs when a man's business is valued as an asset for property division, and then that same business income is used to calculate his alimony and child support obligations. While some states have historical precedents or statutes that forbid double dipping, many others allow it under the guise of equity. For example, if a man's consulting firm is valued at $1 million based on its cash flow, he might pay his spouse $500,000 to keep the business. Then, the judge looks at that same cash flow to determine he can afford $5,000 a month in support. Historically, this has been one of the most contentious areas of American family law, leading to a surge in men seeking prenuptial and postnuptial agreements to opt out of these default historical trends. A key data point to consider is the shift in asset valuation dates. Historically, assets were valued at the time the divorce was filed, but in a volatile 2026 economy, the value of a stock portfolio or a crypto asset can swing 30% in a month. Many states have moved to a date of trial valuation. This creates a high-stakes environment where the timing of your legal proceedings can cost or save you hundreds of thousands of dollars. Case studies from the 2008 financial crisis show that men who were slow to finalize their divorces ended up paying settlements based on pre-crash values with post-crash dollars. Understanding the historical mechanics of valuation dates is essential for any man looking to protect his financial future. Furthermore, we must address the history of wasteful dissipation of assets. While we live in a no-fault era, financial fault still exists. If a man spends marital funds on a girlfriend, a gambling habit, or even high-risk investments that the court deems reckless, the court can add back that money to the marital estate. This means that if you spent $50,000 on a luxury vacation for yourself during the separation, the judge may treat that $50,000 as if it still exists in your bank account and award your spouse a larger share of the remaining assets to compensate. The historical trend here is that the court acts as a moral arbiter of your balance sheet. As we conclude this deep dive into the financial machinery of American legal history, you can see that the rules are rarely as simple as they appear on a government website. The system is a collection of historical compromises between individual property rights and the state's desire for social stability. But the financial side is only half of the story. The true heart of most divorces, and the area where historical bias runs deepest, is the battle over the next generation. The question remains: how did we go from a system where fathers had absolute authority to a system where they have to fight for parenting time? In the next part of this masterclass, we are going to look at the dark history of the tender years doctrine and the psychological theories that stripped millions of men of their parental rights in the 20th century. We will explore how the best interests of the child standard was born and why it is often used as a historical weapon against the non-primary breadwinner. If you think the financial traps are complex, wait until you see the historical mechanics of the American custody battle. In Part 3, we reveal the specific data points that judges use to determine who is the better parent and how you can position yourself within the historical framework of the modern dual parenting movement. Don't let 100 years of legal bias dictate your relationship with your children. The evolution of custody law is the most important history lesson you will ever learn. To understand the battle for your children in 2026, we have to look back at the radical inversion of parenting law that occurred in the United States over the last 2 centuries. For the first 100 years of American history, custody was not a debate. Under English common law, which the U.S. adopted, fathers had a near-absolute right to custody. This was not necessarily based on a belief in superior fatherhood, but rather on the legal status of children as assets and the father's role as the sole provider. If a marriage dissolved in 1820, the father kept the children because he owned the farm, the house, and the means to support them. Women, largely excluded from property ownership, were seen as legally incapable of providing the necessary stability. However, the mid-19th century introduced a massive cultural shift that would redefine the American father's role for the next 150 years. This was the birth of the tender years doctrine. Influenced by the British Custody of Infants Act of 1839, American courts began to adopt the idea that for children of a tender age, usually under 7, The mother was the natural and essential caregiver. This wasn't just a change in preference, it was a total legal pivot. Historical trends show that by 1900, the paternal preference had been completely replaced by a maternal presumption. The legal argument was that a mother's instinct was a biological necessity that no father could replicate. For the American man, this created a historical precedent where he was viewed as the secondary parent by default. Imagine a man named Robert in the year 1950. Robert is a devoted father, but if he seeks a divorce, the law effectively tells him that his role is to provide the check, while the mother provides the care. This was the era of the every other weekend father. But as we moved into the 1970s, the feminist movement and the rise of the psychological sciences challenged these gender-based presumptions. The result was the Uniform Marriage and Divorce Act of 1970, which introduced the standard we live with today: the best interests of the child. On paper, the best interests of the child standard is gender neutral. It was designed to look at each parent as an individual rather than a gendered role. However, in practice, the historical inertia of the tender years doctrine did not vanish overnight. It evolved into what many legal scholars call the primary caretaker rule. In 2026, while the law says both parents are equal, the court often looks at who has historically performed the daily tasks, who takes the child to the doctor, who communicates with the teachers, and who handles the bedtime routine. For many men who have focused on the breadwinning role to provide for their families, this historical metric can feel like a trap. Let's look at a case study of a man named Marcus in 2026. Marcus is a high-earning executive who worked 60 hours a week to pay for a private school and a comfortable home for his 2 daughters. When his marriage ends, his spouse argues that because she was a stay-at-home parent, Marcus is a stranger to his children's daily needs. In a historical context, the court is using Marcus's provision for his family as evidence against his ability to parent them. This is the duality of the modern system. The same labor that makes a man a good provider can be used as a data point to argue he is an absent father. To navigate this, you must understand the 12 to 15 factors that most state statutes use to define the best interests of the child. These include the emotional ties between the parent and child, the capacity of the parents to provide food and medical care, and the mental and physical health of all parties involved. A critical yet often overlooked factor is the moral fitness of the parents. Historically, this meant the court would punish a parent for infidelity. In 2026, moral fitness has evolved. Now, the court looks at which parent is more likely to allow the child frequent and continuing contact with the other parent. This is known as the friendly parent provision. Potential outcomes in 2026 are increasingly leaning toward a 50-50 shared parenting split, but this depends heavily on the state. For example, states like Arizona and Kentucky have passed laws creating a rebuttable presumption that equal shared parenting is in the best interest of the child. This is a massive historical shift. In these states, the burden of proof has flipped. Instead of the father having to prove why he deserves half the time, the mother has to prove why he should have less. However, in states without this presumption, the default often remains a 60-40th or 70-30th split. One of the most dangerous historical traps for a man in a 2026 divorce is the status quo. When a divorce is filed, there is often a period of months before a final trial. During this time, a temporary order is issued. If a man moves out of the house and accepts a limited visitation schedule just to keep the peace, he is inadvertently creating a new historical record. By the time the final trial occurs 18 months later, the judge may look at the current arrangement and decide not to change it because the children have become accustomed to it. This is the legal concept of continuity of care. In the eyes of the court, stability is often more important than absolute fairness. If you accept less than 50% time during the temporary phase, you are fighting a historical uphill battle to get it back later. We also have to analyze the rise of the guardian ad litem or GAL. This is a court-appointed individual, often an attorney or social worker, who investigates the family and makes a recommendation to the judge. Historically, the judge made the call based on testimony. Today, the GAL's report often carries more weight than any other piece of evidence. For a man in 2026, the strategy shifts from convincing a judge to educating a JL. Case studies suggest that men who approach the GAL with a data-driven, non-emotional plan for their children's future have a higher probability of achieving their desired parenting time. Furthermore, we must address the historical shift in how the court views high-conflict cases. In the 1990s, if parents couldn't get along, the court would often give one parent sole custody just to end the fighting. Today we see a move toward parallel parenting. This is a model where parents have minimal contact, but both remain fully involved in the children's lives. This is a historical response to the realization that removing a father from a child's life to reduce conflict was often more damaging than the conflict itself. As we move forward, it is clear that the American legal system is in a state of tug-of-war between its traditional gendered roots and a new egalitarian future. But the legal battle isn't just about who gets the kids on Tuesdays. It's about the massive financial machinery that powers the entire system. Child support is not just a calculation. It is a historical byproduct of the welfare reforms of the late 20th century, and it is tied directly to the amount of time you spend with your children. But what happens when the fight for custody turns into a weapon for financial gain? Why is the dollar amount of your child support directly linked to a 1980s federal mandate? In Part 4, we are going to dive deep into the hidden history of the Title 4D program and how the federal government actually incentivizes states to collect as much child support as possible. We will uncover why your parenting time is a line item on a state budget and the specific steps you can take to protect your income from being swallowed by outdated historical formulas. The intersection of money and children is where the system gets truly complex, and if you don't know the history of the money, you'll never win the battle for the time. To truly understand the financial gravity of child support in 2026, we have to pull back the curtain on a piece of legislation that most American men have never heard of, Title 4D of the Social Security Act. Enacted in 1975, this federal mandate didn't just create a system for tracking down absent parents. It transformed child support from a private family matter into a massive, federally subsidized state industry. Under Title 4D, the federal government provides states with significant financial incentives and matching funds to establish paternity and collect child support. This is the historical engine that drives every calculation in your local courthouse. For every dollar a state agency collects, they receive a percentage back in federal incentive payments. This creates a documented historical trend where state legislatures are incentivized to maintain high child support guidelines to maximize federal funding. Imagine a man named Brandon in the year 2026. Brandon is a middle manager earning $100,000 a year. His spouse earns $40,000. In a pre-1975 world, a judge might have looked at Brandon's expenses and his spouse's needs and picked a number that felt right. But in the Title 4D era, the judge's discretion has been largely replaced by the income shares model. This model, now used in over 40 states, operates on the historical assumption that a child should receive the same proportion of parental income that he or she would have received if the parents were still living together. Step 1 of this process in 2026 involves a rigid worksheet. The court adds Brandon's gross income to his spouse's gross income to find the combined family income. They then look at a statutory table, a historical data set derived from decades of economic studies on child-rearing costs, to find the basic support obligation. In Brandon's case, if the table says a child costs $2,000 a month for a family at their income level, and Brandon earns 70% of the total income, his basic obligation is $1,400. But this is where the historical mechanics get complicated. We have to factor in the overnight count. Most modern states use a parenting time offset. This is a mathematical formula that acknowledges the parent with more time is already spending money directly on the child. However, this creates what legal scholars call the cliff effect. Imagine if Brandon has 127 overnights a year. In his state, the formula might grant him no reduction in support because he hasn't hit the threshold of 128 overnights, which is approximately 35% of the year. The moment Brandon gets that one extra night, night 128, his support obligation might plummet from $1,400 to $800. This one-night difference represents a massive financial shift. Historically, this has led to a high-stakes battle of the overnights, where time with a child is no longer just about bonding. It is a high-value currency. Case studies from 2026 show that litigation frequently centers on these arbitrary thresholds because the financial stakes are so high for both parties. We must also examine the Bradley Amendment of 1986. This is perhaps the most significant historical guardrail in the child support system. Before 1986, if a man lost his job or suffered a medical emergency, a judge could retroactively reduce his child support debt to reflect his actual ability to pay. The Bradley Amendment took that power away. It mandated that child support arrears become a vested judgment the moment they are due. They cannot be retroactively reduced or forgiven by a judge, and they cannot be discharged in bankruptcy. For a man in 2026, this means that if you lose your job on Monday, you must file a motion to modify your support by Tuesday. If you wait 6 months to find a new job, those 6 months of high-level support are permanently etched into your debt profile. The historical trend shows that thousands of men fall into a debt spiral because they were unaware of this 1980s-era federal rule. The state interest here is fiscal. The government wants to ensure that the primary parent does not end up on public assistance, which would cost the state money. By making child support debt permanent and unchangeable, the state shifts the entire economic risk of unemployment or illness onto the paying parent. Now let's consider the concept of imputation of income, a historical doctrine that has gained aggressive traction in recent years. If Brandon decides to quit his high-stress management job to become a teacher because he wants more time with his kids, the court can impute his income. This means they will calculate his child support based on what he could be earning, that $100,000 salary, rather than what he is actually earning. The historical logic is that a parent cannot voluntarily underemploy themselves to avoid their support obligations. While this sounds reasonable in theory, in practice, it often traps men in careers they despise, effectively creating a system of economic conscription, where the historical provider role is enforced by the power of the state. Another deep dive data point is the add-on expenses. In 2026, the basic support figure is just the starting line. Courts now routinely add the costs of health insurance premiums, extraordinary medical expenses, and work-related childcare. In many cases, these add-ons are split pro rata. If Brandon is responsible for 70% of the income, he pays 70% of a $2,000 a month daycare bill. This can often lead to a situation where a man's total support obligation exceeds 50% of his take-home pay. Historical case studies from 2024 to 2026 indicate that standard of living arguments are frequently used to justify high add-on costs, such as expensive extracurricular activities or private tutoring, even if the paying parent never agreed to them during the marriage. Step by step, the calculation of child support has moved from a moral obligation to a bureaucratic algorithm. For the man in 2026, navigating this requires a level of forensic accounting. You have to look at the self-support reserve, a historical protection built into many state guidelines. This is a minimum amount of money the law says a payer must be allowed to keep for their own basic needs, usually based on the federal poverty level. If your support order pushes you below this reserve, you have a historical legal basis to challenge the amount. However, this reserve is often set so low that it barely covers the cost of a studio apartment in most U.S. cities. The intersection of money and children is where the most open loops in the legal system exist. Why is it that a man can be forced to pay support for a child he is legally barred from seeing? Why does the system prioritize the collection of money over the enforcement of parenting time? To answer these questions, we have to look at the history of enforcement versus visitation. While Title 4D provides states with billions to collect money, there is no equivalent federal program that provides states with billions to ensure a father gets his Tuesday nights. This creates a historical imbalance where the state is an efficient debt collector, but an indifferent guardian of parental rights. But even more dangerous than the child support formula is the discovery process, the phase of a divorce where your entire life, from your text messages to your browser history, is laid bare. If you think the financial worksheets are intrusive, you haven't seen the historical weaponization of private data. In Part 5, we are going to dive into the digital forensic revolution in American divorce law. We will explore how your 2026 smart home data, your fitness tracker, and your private emails are being used as historical evidence to dismantle your character in court. We will look at the specific case studies where men lost everything because of a single deleted message. The era of privacy in divorce is over, and if you don't know the rules of the digital battlefield, you've already lost. We will reveal the step-by-step process of electronic discovery and how to protect your digital footprint from becoming a historical weapon against you. The shift from paper discovery to the digital battlefield was formalized in 2006, when the United States Supreme Court approved amendments to the Federal Rules of Civil Procedure. This historical pivot introduced the term electronically stored information, or ESI, into the American legal lexicon. For the man in 2026, this means that the discovery phase of a divorce is no longer about sifting through file folders in a dusty basement. It is a high-tech forensic audit of your entire existence. The historical trend shows that over 90% of all evidence in modern divorce litigation is now digital. This encompasses everything from your private emails and text messages to the hidden metadata embedded in the photos on your phone. Imagine a man named Christopher in 2026. Christopher is a project manager who is involved in a contentious custody battle. He claims in his deposition that he is a homebody who spends every evening with his children. However, his spouse's legal team issues a subpoena for the data from his smart home hub and his Ring doorbell. The historical data from these devices tells a different story. The logs show that the front door was unlocked and relocked at 11 p.m. 4 nights a week for the last 3 months. Furthermore, his smart thermostat data indicates that the house was set to away mode during times he claimed to be present. In 2026, the smart home has become the ultimate silent witness, providing a time-stamped, unalterable record of a man's movements. This leads us to the concept of metadata, which is often described as the data about the data. Every time you take a digital photograph, your phone records the exact GPS coordinates, the altitude, the camera settings, and the precise millisecond the image was captured. Historically, a man could present a photo of himself at a park with his children as evidence of his involvement. Today, a forensic expert can extract the EXIF data from that photo to prove it was actually taken 3 years ago, not last weekend as claimed. Case studies in 2026 highlight that the intentional manipulation of digital evidence is frequently detected through these hidden layers of information, leading to severe potential outcomes for the party attempting to mislead the court. We must also examine the historical evolution of biometric discovery. In the early 2010s, wearable fitness trackers were seen as toys for athletes. By 2026, they are legal landmines. Consider the case study of a man named Michael, who is seeking to reduce his alimony payments by claiming a chronic back injury prevents him from working overtime. His spouse's attorney requests the discovery of his fitness tracker data. The historical trends of his heart rate, step count, and sleep patterns over the last 6 months show that Michael has been engaged in high-intensity cardiovascular activity 4 times a week. The court uses this data to impeach Michael's testimony. This is the new reality of the digital mirror. The data your body produces can be used to contradict the words you speak in a courtroom. Step by step, the process of electronic discovery involves the preservation, collection, and analysis of data. The most critical historical guardrail here is the litigation hold. The moment a divorce is anticipated, not just filed, but reasonably anticipated, both parties have a legal duty to preserve all relevant ESI. If a man in 2026 decides to wipe his hard drive or delete a thread of messages on an encrypted app like Signal or WhatsApp, he is committing what the law calls spoliation of evidence. The historical penalty for spoliation is devastating. Under Federal Rule of Civil Procedure 37E, if a court finds that a party intentionally destroyed ESI to prevent its use in litigation, the judge can issue an adverse inference instruction. This means the judge will tell the jury, or tell themselves in a bench trial, to assume that the deleted information was the worst possible evidence against the person who deleted it. Even if the messages were actually mundane, the act of deleting them creates a historical legal presumption of guilt. In 2026, the delete button is often viewed by judges as a confession. Furthermore, we must address the rise of AI-driven discovery. In the past, lawyers had to manually read thousands of emails. In 2026, law firms use large language models and predictive coding to scan terabytes of data in minutes. These AI tools are trained to identify patterns of behavior, sentiment shifts, and financial anomalies. They can flag every time a man mentioned a specific asset or a specific person over a 10-year period. This has made the hiding of assets nearly impossible. Historical trends in 2026 show that forensic accountants now work hand-in-hand with data scientists to trace cryptocurrency transactions and offshore digital wallets that were once considered untraceable. Imagine a scenario where a man named Justin has been funneling marital funds into a secret Bitcoin wallet for 3 years. He believes that because it is decentralized, it is invisible. However, the discovery process in 2026 includes a request for all bank statements and credit card records, which the AI-driven software scans for small, recurring transfers to known crypto exchanges. Once the link is established, the court can compel Justin to produce his public wallet addresses. If he refuses, the historical precedent of civil contempt can lead to his incarceration until he complies. The digital ledger of the blockchain is a permanent historical record that, once unmasked, provides a roadmap of every financial move he made during the marriage. This level of transparency has fundamentally changed the bargaining power in the shadow of the law. When both parties know that their entire digital lives are accessible, the incentive to settle increases. However, it also opens the door for digital harassment and privacy violations. While the Fourth Amendment protects citizens from unreasonable searches by the government, Those protections are much narrower in a civil divorce case where a spouse may already have legal access to shared accounts or family cloud storage. Historical case studies from the last 5 years show a surge in the use of spyware and stalkerware installed by one spouse on the other's devices. In 2026, many states have enacted specific statutes that penalize the use of such software, but the data obtained, even illegally, can sometimes still create a historical taint on a case that is hard to wash away. As we move through this digital landscape, it becomes clear that a man's reputation is no longer built on his word alone. It is built on his data. The American legal system has adapted to a world where our devices know us better than we know ourselves. But as the physical and digital worlds converge, a new and darker trend is emerging in the halls of justice. It is a trend that moves beyond the facts of data and into the realm of perception and psychology. How does the court handle the situation when the data is weaponized to create a false narrative? What happens when the historical bias of the system is triggered not by a digital log, but by a strategic psychological maneuver? In Part 6, we are going to explore the psychological battlefield of the modern divorce. We will dive deep into the history of parental alienation, the rise of the silver bullet technique, and the specific psychological profiles that judges are trained to look for in 2026. We will uncover how a man can be pathologized by a court-appointed expert, and the historical data behind why some fathers are framed as the villain before they ever open their mouths. The battle for your assets and your children is shifting from the hard drive to the human mind. To understand the psychological battlefield of 2026, we have to look at the transition from physical evidence to the subjective interpretation of the human mind. The American legal system has a long documented history of moving away from hard, objective standards toward nebulous psychological profiles. This shift began in earnest in the 1970s with the publication of Beyond the Best Interests of the Child by Goldstein, Freud, and Solnit. This work introduced the concept of the psychological parent, arguing that the law should prioritize the child's emotional bond over biological or legal rights. For the modern man, this historical pivot created a vacuum where subjective psychological evaluations often outweigh objective facts. Consider the case study of a man named Thomas in 2026. Thomas is a disciplined, successful project manager who has always maintained a structured household. In his mind, providing stability and boundaries is the hallmark of good fatherhood. However, during his divorce, his spouse employs what legal historians call the silver bullet. This is a tactical maneuver where one party makes an allegation of domestic violence or child abuse at the very start of the proceedings. Historically, this tactic is highly effective because of the ex parte hearing. In an ex parte hearing, a judge can issue a temporary restraining order based solely on the testimony of one party, without the other party even being present. For Thomas, the impact is immediate. In a single afternoon, he is legally removed from his home and barred from seeing his children. The historical trend in U.S. family law since the 1990s has been one of extreme caution. Judges are often more concerned with the potential political and legal fallout of failing to act on a false allegation than they are with the immediate due process rights of the father. Once the silver bullet is fired, Thomas is no longer a father in the eyes of the court. He is a defendant. He must now spend the next 12 to 18 months proving a negative, while the status quo of his absence becomes the children's new reality. This leads us to the historical development of parental alienation. This concept was first formalized by Dr. Richard Gardner in 1985 as parental alienation syndrome. Gardner observed a trend where one parent would systematically program a child to reject the other parent. While the term syndrome has been a point of historical contention and was not included in the DSM-5, the underlying behavior is recognized in 2026 under the diagnosis of parent-child relational problem. The legal history of this issue shows a fascinating tug-of-war. In the early 2000s, fathers began successfully using alienation as a defense. In response, a historical counter-movement emerged, arguing that allegations of alienation were merely a way for abusive fathers to deflect blame. In 2026, the court-appointed custody evaluator is the arbiter of this psychological war. These evaluators are often private psychologists who charge thousands of dollars to interview the family and perform testing. One of the most common tools used is the MMPI-3, or the Minnesota Multiphasic Personality Inventory. This test was designed to identify psychopathology, not to determine who is a better parent. However, the historical trend has been to use these tests to pathologize the father. If Thomas is angry or defensive about being falsely accused and removed from his home, his test results may show high levels of paranoia or hostility. The evaluator then presents a report to the judge claiming that Thomas is mentally unstable, completely ignoring the historical context that his reaction is a normal human response to a traumatic legal event. The step-by-step weaponization of psychology often follows a predictable pattern. First, the primary parent creates a narrative of fear. Second, the children are coached to repeat specific phrases that mirror that fear, such as saying they feel unsafe around their father, without being able to provide specific examples. Third, the evaluator interprets the father's attempts to defend himself as a lack of insight or a lack of empathy for the children's supposed fear. This creates a historical loop where the more a man fights for his rights, the more he is seen as high conflict or narcissistic. Data from the early 2020s suggests that in cases where domestic violence is alleged, the accused father is statistically less likely to receive even joint custody, even if the allegations are never proven in a criminal court. This is because the family court operates under the preponderance of the evidence standard, which means 51% certainty, rather than the beyond a reasonable doubt standard used in criminal law. For the man in 2026, this lower evidentiary bar is a historical trap. A single exaggerated text message or a witness who misinterprets a loud argument can be enough to tip the scales and trigger a historical loss of parental rights. We also have to analyze the archetype of the villain that has been historically constructed in family court. There is a documented bias where traditional masculine traits are reinterpreted through a clinical lens. A father who is firm about schoolwork is labeled as rigid. A father who is stoic during a crisis is labeled as emotionally unavailable. A father who is assertive in court is labeled as aggressive. This historical pathologizing of masculinity has led to a system where men feel they must perform a version of fatherhood that the court finds palatable, rather than the version that is actually authentic to them. Case studies in 2026 show that the most successful counter-strategy for men in this position is the use of a parenting coordinator and the demand for parallel parenting. Historically, if parents could not cooperate, would award sole custody to the mother to minimize conflict. Parallel parenting is a historical response that allows both parents to remain involved while having zero contact with each other. It acknowledges that the conflict is often a byproduct of the litigation itself, not an inherent flaw in the parents. Furthermore, the rise of reunification therapy has become a historical bridge for alienated fathers. This is a court-ordered process where a specialist works to repair the damaged bond between the child and the rejected parent. However, historical data shows that the success of reunification therapy is highly dependent on how much time has passed. The longer the alienation persists, the more difficult the historical damage is to undo. The psychological battlefield is designed to wear a man down through attrition. The goal of the opposing side is often to trigger a breakdown, which can then be used as evidence of unfitness. For the man in 2026, the historical lesson is one of emotional regulation. Every interaction with the spouse, every email, and every minute of parenting time is being recorded for a future psychological report. You are not just being a father, you are creating a historical record for a psychologist who will eventually judge your fitness. But even if you win the psychological war, and even if you protect your assets, there is a final, formidable wall that every man must face: the courtroom itself. The American courtroom is a theater of specific rituals, rules of evidence, and judicial discretion that can render even the best psychological report useless, if not navigated correctly. Why do some judges ignore the data and follow their gut? How does the history of judicial immunity protect those who make life-altering mistakes in your case? In Part 7, we are going to walk through the doors of the courthouse and analyze the anatomy of a trial. We will explore the history of the bench trial versus the jury trial in family law, and why the U.S. is one of the only developed nations that allows a single person to decide the fate of an entire family. We will reveal the specific tactics used in cross-examination to break a man's composure, and the historical precedents that allow a judge to disregard the law in favor of equity. The psychological war is over. The legal battle is just beginning. To step through the doors of a United States family courthouse in 2026 is to enter a world that operates on a completely different set of historical and legal principles than the rest of the American justice system. Most citizens grow up believing in the Seventh Amendment of the Constitution, which provides that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. However, for the American man in a divorce, this constitutional protection is almost entirely non-existent. Historically, divorce was not a suit at common law, it was a suit in equity. This distinction, rooted in the 18th century English Court of Chancery, means that in 49 out of 50 states, you have no right to a jury. Only Texas maintains a limited historical tradition of allowing juries to decide certain custody matters. In the rest of the country, your assets, your income, and your relationship with your children are decided by a single individual, the judge. This is what we call a bench trial, and understanding the historical mechanics of the bench is the difference between a calculated legal strategy and a catastrophic failure. The bench trial is governed by the historical principle of judicial discretion. In the original Chancery Courts of England, the judge was known as the Chancellor, and he acted as the king's conscience. His job was not to follow the strict, rigid rules of law, but to do what was equitable or fair. While this sounds noble, the historical trend in American legal studies shows that equity is often synonymous with subjectivity. When a judge has broad discretion, their personal life experiences, their political leanings, and their internal biases regarding gender roles become the shadow law of the courtroom. In 2026, a judge might look at a man who has worked 80 hours a week for 20 years to build a family legacy and decide, in the name of equity, that his spouse should receive 60% of the marital estate because the spouse has a lower future earning capacity. The law doesn't require this outcome, but judicial discretion allows it. Imagine a man named Kevin in the year 2026. Kevin is a successful engineer who has been married for 15 years. He enters his trial with a mountain of evidence showing that he has been the primary financial provider and a consistent, involved father. However, Kevin is appearing before a judge who has spent 20 years as a child advocate before being appointed to the bench. This historical background of the judge is a critical data point. During the trial, the judge exerts God-mode power over the proceedings. If Kevin's attorney tries to introduce a series of text messages showing the spouse's history of erratic behavior, the judge can simply rule them cumulative or irrelevant and refuse to let them into the record. Because there is no jury to serve as a check on the judge's power, the atmosphere of the trial is dictated entirely by the temperament of the robe. This leads us to the historical evolution of the rules of evidence in family court. While the federal rules of evidence serve as a guideline, family court judges often operate under a relaxed evidentiary standard. This is a double-edged sword for men. On one hand, it allows for a more informal discussion of the family's needs. On the other hand, it allows for the introduction of hearsay and character assassination that would never be permitted in a criminal or high-stakes civil trial. Case studies from 2025 and 2026 show a rising trend where hearsay exceptions are used to allow children's coach statements to be admitted into evidence without the child ever having to testify or be cross-examined. For a man like Kevin, this means he is fighting shadows. He is defending himself against statements he cannot directly challenge. The anatomy of a trial moves from opening statements to the presentation of evidence, but the most dangerous phase for any man is cross-examination. Historically, cross-examination is described as the greatest legal engine ever invented for the discovery of truth. In a divorce trial, however, it is often an engine for the creation of controlled rage. The opposing attorney's goal in 2026 is not to find the truth, but to trigger a specific historical archetype, the angry man. They will use a rapid-fire questioning technique designed to interrupt Kevin, prevent him from explaining his answers, and force him into yes or no corners. If Kevin tries to explain the context of a situation, the attorney will immediately state, "Move to strike as non-responsive, Your Honor." The historical trend in judicial observation is that the judge is watching Kevin's reaction more than they are listening to the answer. If Kevin raises his voice, sighs in frustration, or shows even a hint of aggression, the judge's clerk is making a note that Kevin is difficult or uncooperative. This credibility assessment is the silent killer of many men's cases. Once a judge decides a man is not credible, they will begin to view every piece of evidence he presents through a lens of skepticism. This is why emotional regulation is not just a psychological tip. It is a fundamental requirement of American legal procedure. We must also analyze the historical precedent of judicial immunity. This is a concept reinforced by the 1978 Supreme Court case Stump v. Sparkman, which established that judges are immune from being sued for their judicial acts, even if those acts are erroneous, malicious, or in excess of their authority. For the man in 2026, this means there is zero accountability for a judge who makes a mistake. If a judge miscalculates your child support by $2,000 a month because they didn't understand your tax returns, you cannot sue the judge for the error. Your only recourse is the appeals process. However, the history of the American appellate system shows that it is a cold record review. An appellate court will not hold a new trial. They will only look at the transcript of what was said in the trial court. They give great deference to the trial judge's findings of fact. This means that if the trial judge says, "I found the husband to be less credible than the wife," the appeals court will almost never overturn that decision. Historically, 90% of family law appeals fail because they are challenging a judge's discretion, rather than a clear error of law. This is why the trial is not just the beginning of the end. For most men, the trial is the end. To navigate this, a man must understand the pre-trial motion strategy. Historically, the most successful potential outcomes are not reached at trial, but in the months leading up to it. In 2026, the use of motions in limine, which are requests to exclude certain evidence before the trial even starts, is the most effective way to tie the judge's hands and prevent a character assassination defense. If you can legally bar the opposition from bringing up an irrelevant event from 10 years ago, you have successfully narrowed the judge's discretion. But as we peel back the layers of the American courtroom, we find that the judge is not the only person in power. There is a hidden network of professionals who operate in the back channels of the legal system. These are the mediators, the evaluators, and the special masters, who often decide the outcome of a case before the parties ever sit at the counsel table. Why do voluntary mediations often feel like a shakedown? How does the informal history of the judge's chambers influence your formal decree? In Part 8, we are going to expose the shadow judiciary. We will dive into the history of the multi-door courthouse and the rise of alternative dispute resolution. We will reveal the specific tactics used in mediation to force men into voluntary agreements that they later regret. We will look at the case studies of MedArb and why giving a third party the power to both mediate and arbitrate your life is one of the most dangerous historical shifts in modern law. The courtroom is the stage, but the real deals are made in the dark. We are going to turn the lights on. To understand the shadow judiciary of 2026, we have to travel back to the 1976-pound conference, where Harvard law professor Frank Sander proposed a revolutionary concept known as the multi-door courthouse. Sander's vision was a legal system where a single building would offer multiple doors for dispute resolution. Not just a trial, but mediation, arbitration, and neutral evaluation. While this was framed as a way to increase efficiency and lower costs for the public, the historical trend over the last 50 years has seen these doors become a mandatory filter that every man must pass through before he is ever allowed to see a judge. In the modern American legal system, the courthouse is no longer a place where you go to fight. It is a place where you are sent to settle. This shift from public adjudication to private negotiation has profound implications for the American man, creating a historical environment where the constitutional right to a day in court is effectively replaced by a high-pressure, closed-door business transaction. Imagine a man named Brian in the year 2026. Brian is a small business owner who has spent 18 months in a high-conflict divorce. He has paid his attorney $40,000, and he is ready to tell his side of the story to a judge. However, his state's historical rules of procedure mandate that he attend a minimum of 12 hours of mediation before a trial date can even be requested. Brian is told that mediation is voluntary, but this is a historical half-truth. If Brian refuses to participate in good faith, or if he is seen as an obstructionist in the mediation room, his spouse's attorney will file a motion for sanctions. The judge, who is overwhelmed by a docket of thousands of cases, will view Brian's desire for a trial not as an exercise of his rights, but as a failure of his character. In 2026, the system is designed to punish those who insist on their day in court. The historical engine of this shadow judiciary is alternative dispute resolution, or ADR. In 1998, the United States Congress passed the Alternative Dispute Resolution Act, which required every federal district court to implement an ADR program. This federal mandate trickled down to state family courts, creating a massive private industry of mediators and arbitrators. For the man in 2026, this means that the most critical decisions of his life, how much he will pay in support and how often he will see his children, are often decided in a windowless conference room, led by a third-party neutral who is not bound by the rules of evidence or the formal law. Step by step, the mediation process in 2026 follows a tactical pattern designed for attrition. The mediator often uses a technique called caucusing, where the parties are placed in separate rooms. The mediator then shuttles back and forth, engaging in what they call reality testing. For Brian, reality testing feels like a coordinated psychological assault. The mediator will sit with Brian and highlight every single weakness in his case. They will tell him that the judge he is assigned to is having a bad month, or that the judge historically dislikes business owners who don't have perfect record keeping. They will warn him that a trial will cost him another $50,000, and that the potential outcomes are unpredictable. This is the sunk cost fallacy being used as a legal weapon. By focusing Brian on the fear of loss rather than the hope for justice, the mediator drives him toward a middle ground that he would never have accepted at the start of the process. We must also analyze the case study of MedArb, a hybrid process that has gained historical traction in recent years. In MedArb, the parties agree that if they cannot reach a settlement in mediation, the mediator instantly transforms into an arbitrator with the power to issue a binding, unappealable decision. For the man in 2026, this is perhaps the most dangerous door in the multi-door courthouse, because the mediator has spent the day listening to confidential, off-the-record settlement offers. They are now biased by information that would never be admissible in a court of law. If Brian admitted during mediation that he might be willing to pay $2,000 a month just to end the stress, and the mediation fails, that same person, now acting as an arbitrator, will likely use that number as the floor for their decision. Historically, MedArb represents a total surrender of the procedural safeguards that have protected American citizens for 200 years. Data from the American Bar Association indicates that over 95% of family law cases now settle before trial. While the legal industry celebrates this as a success, historical analysis suggests a different narrative. The settlement culture has created a tiered justice system. Wealthier men can afford to bypass the pressure of mediation by hiring private judges, retired jurists who charge upwards of $1,000 an hour to conduct a private trial. For the average man, however, the only option is the state-mandated mediation loop. This has led to the rise of what legal scholars call coerced consent. Brian eventually signs a settlement agreement not because he agrees with it, but because he is financially and emotionally exhausted. Once that signature is on the paper, it becomes a historical fact. The court will incorporate that agreement into a final decree, and Brian has now waived his right to appeal. Furthermore, we have to look at the shadow bar, the informal network of attorneys and mediators who work together every day. In many jurisdictions, the mediator is a former colleague or a close friend of the opposing attorney. This historical familiarity creates a back channel, where your case is discussed in ways you will never know. Case studies from 2025 show that informal recommendations made by a mediator to a judge during a status conference can tilt the trajectory of a case before a single witness is ever called. For the man in 2026, the transparency of the public trial has been replaced by the opacity of the professional club. The final historical trap of the shadow judiciary is the Memorandum of Understanding, or MOU. At the end of a long mediation session, when Brian is starving, tired, and desperate to go home, the mediator will produce a handwritten or typed summary of the points agreed upon. They tell Brian it is just a working document. However, historically, if Brian signs that MOU, it is often treated by the court as a binding contract. If he wakes up the next morning and realizes he made a catastrophic financial mistake, he will find that the voluntary mediation he attended has now become a permanent legal cage. As we conclude this deep dive into the shadow judiciary, it is clear that the modern divorce is not won in the courtroom, but in the halls and side rooms where the rules are flexible and the pressure is constant. But even if Brian signs the agreement, and even if the decree is finalized, his journey through the American legal machine is not over. He has entered the world of post-decree life, where the law continues to monitor his every move. What happens when the final order isn't actually final? Why can a spouse return to court years later to take another bite of the apple? In Part 9, we are going to explore the perpetual litigation model of modern divorce. We will dive into the history of modifications, the rise of contempt of court as a weapon of harassment, and the specific data behind the alimony for life traps that still exist in 2026. We will reveal how the system ensures that a man is never truly divorced, as long as there is still wealth to be redistributed or a grudge to be settled. The ink may be dry on the paper, but the historical engine of enforcement is just getting started. The concept of finality is one of the most significant legal illusions in the American domestic relations framework. In almost every other area of American law, once a judgment is signed and the time for appeal has passed, the case is considered closed under the historical doctrine of residential judicata, meaning a matter already judged. However, family law operates under a different historical precedent known as continuing jurisdiction. This means that the court which issued your final decree maintains a permanent, open-ended power over your life until the last child reaches the age of majority or the last alimony check is cashed. For the American man in 2026, the final decree is not a finish line. It is a set of rules for a game that can be restarted at any moment by the filing of a single motion. Imagine a man named Stephen in the year 2026. Stephen finalized his divorce in 2024. He was diligent, he followed the advice of his counsel, and he accepted a settlement that he felt was high but manageable. He moved into a new apartment, focused on his career in the growing renewable energy sector, and by 2026, he received a significant promotion due to his expertise in grid-scale battery storage. Within 3 months of his promotion being announced on a professional networking site, Stephen is served with a motion for modification of child support. Under the historical trend of the income shares model we discussed in Part 4, his ex-spouse is now seeking to capture a percentage of his new success. Stephen's legal journey has not ended. It has simply entered its second act, the era of perpetual litigation. To understand how Stephen finds himself back in a courtroom, we must analyze the historical standard of a substantial change in circumstances. This is the gatekeeper of the modification process. Historically, the law recognizes that life is not static. Inflation, career changes, medical emergencies, or a child's changing needs can all render a 2024 order obsolete by 2026. In most U.S. jurisdictions, a substantial change is defined mathematically. If the new calculation would result in a change of 10 to 15% in the monthly support amount, the court historically views this as enough to justify a full modification hearing. This creates a historical incentive for what legal scholars call bracket creeping, where a party monitors the other's lifestyle and income for any upward movement that might trigger a new payday. Step by step, the modification process mirrors the original divorce discovery process. Stephen must once again produce 3 years of tax returns, 6 months of pay stubs, and updated financial affidavits. The historical data shows that modifications are often more streamlined and faster than the original divorce, but for the man paying the support, the cost of defense can often exceed the amount of the potential increase. This is the attrition model of modern family law. If it costs Stephen $5,000 in legal fees to fight an increase of $200 a month, he faces a difficult mathematical choice that the system is historically designed to exploit. We also have to examine the historical evolution of alimony modifications, specifically concerning the concept of cohabitation. In the early 20th century, alimony almost always terminated upon the remarriage of the recipient. However, as social norms shifted, many recipients began opting for long-term cohabitation rather than legal marriage to maintain their alimony stream. This led to the birth of the cohabitation statute in various states. In 2026, if Stephen's ex-spouse is living with a new partner, Stephen may have the right to reduce or terminate his alimony payments. But the historical burden of proof is on Stephen. He must prove an economic partnership. This involves a deep dive into the ex-spouse's private life to show that they are sharing expenses, have joint bank accounts, or are functioning as a single economic unit. Case studies from 2024 to 2026 show that this is one of the most litigious and expensive areas of post-decree life, often requiring the hire of private investigators and forensic data analysts to prove a historical pattern of shared residency and financial commingling. The law provides the door for relief, but the historical cost of opening that door is often prohibitively high. Then there is the darker side of enforcement, the motion for contempt. In the American legal tradition, family court is one of the few remaining places where a citizen can be incarcerated for a debt. This is historically justified by the distinction between a civil debt and a court-ordered support obligation. If Stephen misses a payment, or even if he falls behind on an add-on expense like a summer camp fee, he can be found in willful contempt. The historical trend in U.S. courts since the landmark Supreme Court case of Turner v. Rogers in 2011 is that while a man has a right to an ability to pay hearing, he does not necessarily have a right to a court-appointed attorney if the state can show the proceedings are not unusually complex. Imagine Stephen loses his job in a 2026 market downturn. If he fails to file a motion to modify immediately, as we discussed in Part 4 regarding the Bradley Amendment, his debt continues to accrue. His ex-spouse files for contempt. At the hearing, the judge sets what is known as a purge amount. This is a specific dollar amount Stephen must pay to stay out of jail, or to be released. Historically, the purge amount acts as a keys to the jail cell mechanism. The system assumes that even if Stephen has no income, he can somehow find the money from friends, family, or retirement accounts. This historical pressure is the primary driver of the high rates of post-decree settlements where men give up even more assets just to avoid the threat of incarceration. Furthermore, we must address the perpetual custody battle. In 2026, the best interest standard remains the historical metric for modifying parenting time. If the ex-spouse decides they want to move to a different state, a relocation case, the entire custody arrangement is thrown into a historical blender. Relocation laws in the U.S. have swung like a pendulum. In the 1990s, the trend favored the moving parent. In the 2010s, it swung toward the parent staying behind. In 2026, many states use a neutral burden of proof, but the reality is that the man often finds himself fighting a distance-based alienation where his role is reduced to a Zoom father due to the historical preference for the primary caretaker's autonomy. The data also reveals the rise of the vexatious litigant in family law. These are individuals who use the court's continuing jurisdiction as a tool of harassment, filing motion after motion for minor or imagined infractions. While some states have historical statutes to bar such filings, they are rarely used in family court because judges are afraid of violating a parent's right to petition for the welfare of the child. For a man in 2026, this means that even if you follow every rule, you can still be dragged into court repeatedly, incurring thousands in fees, simply because the other party has the time and the grudge to do so. This perpetual state of legal readiness has a profound historical impact on a man's ability to build a new life. It affects his credit, his ability to get a mortgage, and his mental health. The system, historically designed to ensure the state does not have to pay for the family, creates a long-tail liability for the man that can last decades. But as we reach the final part of this masterclass, we have to look beyond the litigation. We have to look at the end game of the American legal experience. What is the ultimate historical legacy of this system on the American family? Is there a way to exit the machinery entirely and find a path to true legal and personal autonomy? In our final part, Part 10, we are going to synthesize everything we have learned. We will look at the emerging private contract movement, the historical trend of marriage detachment, and the specific strategies that the most successful men in American history have used to insulate themselves from the perpetual litigation loop. We will reveal the grand strategy for 2026 and beyond, how to win the peace after you have survived the war. The final piece of the puzzle is the most important one. It's not just about surviving the law, it's about transcending it. To transcend the American legal machine in 2026, we have to master the historical shift from status to contract. In the 19th century, legal scholar Sir Henry Maine famously observed that the movement of progressive societies has hitherto been a movement from status to contract. For over a century, marriage was a status, a rigid state-defined cage with rules you didn't write and couldn't change. But in 2026, the most successful potential outcomes for men are found by those who treat marriage and its dissolution as a contract. This is the grand strategy. Moving from being a passive subject of the state to an active architect of your own legal reality. We are exiting the era of the standardized victim and entering the era of private ordering. Imagine a man named James in the year 2026. James is entering his second marriage, but he is doing so with the historical scars of a primary divorce that cost him 40% of his net worth. James doesn't just sign a marriage license. He utilizes a comprehensive private ordering agreement. Historically, the Supreme Court case of Marvin v. Marvin, 1976, set the stage for this by recognizing that adults can form private contracts regarding their earnings and property, even outside of traditional marriage. James's strategy in 2026 involves a choice of law clause. Because he lives in a state with aggressive equitable distribution laws, his contract stipulates that any dispute will be governed by the laws of a state like Texas or Florida, which may have more favorable historical precedents regarding the protection of premarital business growth. This is the first step in winning the peace, deciding which historical rules you are willing to play by before the game even begins. The second pillar of the grand strategy is financial insulation through the historical lens of trust law. For centuries, trusts were the exclusive tools of the ultra-wealthy, but in 2026, they have become a standard defensive maneuver for the middle-class professional. To understand this, we look at the historical trend of domestic asset protection trusts, DAPs. Historically, the law allowed creditors, including a divorcing spouse, to reach any assets you could access. However, starting with Alaska in 1997, a new historical precedent emerged allowing for self-settled spendthrift trusts. Step by step, James places his primary business interests and his inherited family land into a DPT years before any marital strife occurs. In the eyes of a 2026 court, these assets are no longer owned by James, they are owned by the trust. When the marital property theory we discussed in Part 2 attempts to claim active appreciation on these assets, the historical shield of the trust creates a formidable barrier. The burden of proof shifts to the spouse to prove a fraudulent transfer, a historical legal standard that is significantly harder to meet than a simple equitable distribution claim. By separating your legal identity from your asset ownership, you are utilizing 500 years of English trust law to insulate your future from the volatility of modern family court. But the grand strategy isn't just about money. It's about the abolition of conflict through the collaborative law movement. Historically, the American legal system is adversarial. One side must lose for the other to win. This historical structure is what drives the legal fees to the moon phenomenon. In 2026, the Uniform Collaborative Law Act, which has been adopted by a majority of states, offers a historical off-ramp. In a collaborative model, both parties and their attorneys sign a contract that prohibits them from going to court. If the process fails, the attorneys are disqualified from representing the parties in any future litigation. This creates a historical incentive for the lawyers to settle rather than to fight. For a man like James, this means his adversary is no longer the state-funded machinery of the courthouse, but a private negotiation where the historical bias of the angry man archetype has less room to breathe. Case studies in 2026 show that collaborative cases are finalized 30 to 40% faster and result in significantly higher rates of long-term compliance with parenting plans. You are winning the peace by refusing to set foot on the battlefield in the first place. Now let's address the digital peace protocol. As we explored in Part 5, the digital world is a minefield. The grand strategy in 2026 involves the normalization of transparency through technology. Successful men are now using third-party parenting portals like Our Family Wizard or Talking Parents as their primary historical record. These apps were born out of a historical need to reduce he said, she said litigation. Every message is time-stamped, every calendar change is logged, and the tone of every communication is analyzed by AI. By insisting on these tools in the final decree, James creates a permanent historical ledger that protects him from the silver bullet tactics discussed in Part 6. If an allegation of missed visitation or aggressive communication is made, James doesn't need to argue, he simply prints the report. The historical data shows that when a high-conflict spouse knows their every word is being recorded by a court-monitored system, the rate of psychological weaponization drops precipitously. This is the use of the digital panopticon as a shield for the innocent. Furthermore, we must synthesize the Stoic legal philosophy. Historically, men lose in family court because they react to the perceived injustice of the system with emotion. The grand strategy requires a shift to legal realism. You must accept the historical fact that the system is tilted, that the tender years doctrine still has ghosts in the courtroom, and that the state has a fiscal interest in your income. Once you accept these as environmental hazards, rather than personal attacks, you can navigate them with the cold precision of a chess player. Imagine James at his final hearing. He doesn't seek fairness, which is a subjective historical myth. He seeks statutory compliance. He knows the child support formula, he knows the alimony caps, and he knows the self-support reserve. He presents his case as a series of data points that a judge can easily check off, making it historically difficult for the judge to deviate from the standard without being overturned on appeal. James wins by becoming the most boring, most compliant, and most prepared person in the room. The ultimate historical legacy of this 10-part masterclass is the realization that the American family is undergoing its third great transformation. The first was from the patriarchal unit to the companionate marriage in the early 20th century. The second was the no-fault revolution of the 1970s. The third, which we are living through in 2026, is the atomization of the family. As the state retreats from defining what a family is, the individual man must take up the mantle of defining his own rights through contract, trust, and technology. You have now completed the deep dive masterclass on American legal history studies as it pertains to the modern man. You have the historical context of alimony, the data behind the Title IV defunding, the mechanics of digital discovery, and the grand strategy of contractual autonomy. You are no longer an uninformed defendant. You are a student of the law, and in the American system, knowledge is the only true form of equity. But as the legal landscape of 2026 continues to shift, new questions are emerging on the horizon. What happens when the artificial intelligence we use for discovery begins to be used by the judges themselves to predict parental unfitness? How will the rise of decentralized finance and smart contracts fundamentally change the way we handle property division in 2027 and beyond? The era of the lawyer in the robe may be coming to an end, replaced by the algorithm on the bench. In our next series, we will explore the rise of the robo-judge and how the next decade of American law will be decided not by historical precedent, but by predictive modeling. If you thought the 1970s revolution was big, you haven't seen anything yet. Subscribe and stay tuned as we dive into the future of justice in the age of the machine. The piece you've won today is just the beginning of the next level of the game.